Good afternoon.
Yes, Mr. Bess.
To answer the question before the short adjournment, the relevant version of the CRA is that at the date of the contract, pursuant to section 16(1) of the 1978 Interpretation Act. Rome 1.
So the right version is in fact the one set out in the judgment, as it happens.
Yes, not in the authorities bundles that have been provided and referred to this morning.
Yeah, okay.
But no material difference.
Indeed.
The judge was right to use Rome 1 analysis as a sense check on close connection. Close connection being the test he still correctly applied. He was right to do this given the mischief in Article 6.2 of the 1993 directive. The common factor across section 74.1 CRA and Articles 4.3 and 4.4 of Rome 1 is that the court may take into account all the circumstances in answering different but similar questions as to degrees of connection. Under section 74.1, that follows from Commission against Spain, paragraph 32. For Articles 4.3 and 4.4, we rely upon the passages from Dicey, which are in Authorities Volume 2, tab 60, hard copy, page 1909. So e-version should be 1886. It is section 32-131 addressing Article 4.3. The editors say Article 4.3 refers to all the circumstances of the case and there is no limit to the types of factor which may be taken into account, provided they are outwardly ascertainable and relevant to the contract at the time of its conclusion. The court must determine the significance of each factor in connecting the contract on the one hand to the country whose law applies under Article 4.1 or 4.2 and on the other to another country with which a close connection exists. This is not a simple counting exercise. Recital 20 states that account should be taken inter alia of whether the contract in question has a very close relationship with another contract or contracts. And this is undoubtedly a significant factor when it exists. And we say there is an analogy here, of course, with the subscription agreement. If one then please turns over the page to paragraph 32.132, we see a similar explanation as regards Article 4.4. The range of factors that may be taken into account for this purpose is the same as for Article 4.3, although a broader evaluative judgment is now required. Under Article 4.4, this is the last sentence, by contrast with 4.3, the court is looking for a simple preponderance of connecting factors, identifying the centre of gravity of the contract, and not a clear preponderance of factors favouring one country. In summary, we refute the suggestion that the judge was mistaken to talk about closeness as an inherently relative concept. If a contract is manifestly more connected with country A, it is highly unlikely, albeit not impossible, that it will have a close connection with country B. Taking account of all the circumstances in an international scenario, there are likely to be various indicia that connect the contract with different jurisdictions. Those indicia have to be weighed to see if they include indicia that amount to a close connection with the UK. Each indication of a connection with country A, say Hong Kong, is likely to be a contra-indication of a connection or a close connection with country B, say the UK. That is not to adopt a linear approach, as my learned friend says. The more the indicia point to connectedness with another country, here Hong Kong, the less likely there will be the required close connection with the UK. The flaw in my learned friend's submissions today was that when he went through Articles 4, 2 and 3, he said that the Article 4.2 characteristic performer presumption should have added inertia for a consumer contract, specifically where the consumer was the characteristic performer, with the result that the law of the residence applies. But we say that would be to make Article 6 of Rome 1 practically redundant, at least where the consumer is the characteristic performer. One would never have to ask, have the activities been directed at the UK, because one would anyway have characteristic performer law of the residence pursuant to Article 4.2. So we don't accept that there is a special application of Article 4.2 and the characteristic performer presumption that applies in consumer cases.
I suppose the other way of formulating that point might be to say that if something is not directed or targeted at the UK, then that is indicative, or maybe indicative, of the absence of a close connection.
When one is looking at close connection, whether under Section 74 or under the waterfall of Article 4, Rome 1, yes, we agree, because that direction of activities, for example, to France, where the consumer was when they purchased the product on holiday, would itself be a contraindication of a connection with the UK. When one is weighing this question of fact and degree and taking account of all the circumstances of the case, as per Commission in Spain, each indicia will have both a positive effect and a negative effect, insofar as it points to, say, France in my example, and away from, if we're dealing with Section 74, the UK. So unless there are any questions, that's all I wanted to say on the judge's Rome 1 sense check. And I turn to the facts on close connection. Our submissions are at paragraphs 21 to 22 of our skeleton. The judge correctly held that the PG had an overwhelming connection with Hong Kong and relatedly insufficient connection with the UK to amount to a close connection. In summary, the consideration for which the PG was given was the advance of 500 million Hong Kong dollars by one Hong Kong registered company to another Hong Kong registered company, the latter also being listed on the Hong Kong Stock Exchange. It's unnecessary for me to paraphrase or reword the facts at paras 108 to 112 of the judgment, on which we continue to rely. We say that the judge correctly relied upon all the matters set out there at 108 to 112 in finding the overwhelming connection with Hong Kong and the lack of close connection with the UK. With one minor caveat, on paragraph 112, we do say that the fact the PG was signed in Spain means that it was even less connected with the UK than it would otherwise have been. Contrary to the second error my learned friend posited this morning, the judge did not draw the circle too tightly. We say rather it is Mrs. Zhang who is seeking to draw the circle too tightly with her myopic focus upon residence as creating a close connection with the UK. So rather than rehash what the judge says, I wanted to show your lordships the subscription agreement and the personal guarantee and the various Hong Kong connections therein. First, the subscription agreement, that is in supplemental bundle 2. Please, tab 2, page 9. And if one starts, please, on page 11, we see that the company is Credit China, later renamed Chongqing, having its principal place of business in Hong Kong. Eternity Sky is the second party. Its registered office is in BVI, but in reality it was Hong Kong registered. That's judgment, paragraph 109. Recital A, the company was listed on the growth enterprise market of the stock exchange. We'll see in a moment that that is a defined term, meaning the stock exchange of Hong Kong. And recital C, there is a summary of the underlying business of Chongqing, which had nothing to do with the UK. Applicable laws is defined towards the bottom of the page and includes a reference to governmental authority or the stock exchange, and we'll see the definition of stock exchange in a moment. Over the page, on page 12, the company's ordinance to which this contract refers is that of the laws of Hong Kong. Page 14, please. The GEM listing rules are the rules governing the listing of securities on the growth enterprise market of the stock exchange. There's the definitions of guarantee and guarantor you were shown, definitions of Hong Kong dollar and Hong Kong. Over the page, page 16, please, is that definition of the stock exchange as the stock exchange of Hong Kong. Page 18. Represent what clause 4 on listing. The bonds themselves are not to be listed on any stock exchange, but the company confirms that it shall, as soon as practicable following the execution of this agreement, make an application to the stock exchange, i.e. of Hong Kong, for the listing of and permission to deal in the conversion shares. So if the bonds are converted into shares, then they themselves will be on the Hong Kong Stock Exchange. Representations and warranties at 5.1.1 and 5.1.2 are Hong Kong focused. Similarly, at page 19, 5.1.10d is a representation and warranty that relates to the potential conversion shares and their listing on the stock exchange in Hong Kong. Page 20, 5.1.16, the company being Hong Kong focused represents and warrants that its audited financial statements comply with Hong Kong accounting standards. Page 25, clause 7.1 has as one of the conditions precedent at 7.1.1 the Hong Kong Stock Exchange having granted all necessary approval for the listing and permission to deal in the conversion shares and the issue of the bond. Page 26, clause 8.3. The subscriber, that's Eternity Sky, is to pay the face value of the bonds to the company in Hong Kong, and that is the consideration for the guarantee, not just a clause in the subscription agreement. Page 27, clause 10 on notices. The Hong Kong focus is exemplified by both parties having addresses in Hong Kong. Page 30, clause 15. The subscription agreement is governed by Hong Kong law, and over the page on page 31 also provides for HKIAC arbitration. Seat, Hong Kong. Finally, page 34, there is a schedule of particulars of the company with, again, a number of Hong Kong elements. Turning to the PG itself, that's behind tab 3, page 37. The recitals are on page 38. Recital A refers to that subscription agreement and the bond issue for Hong Kong $500 million. Recital C explains how the guarantor has agreed to enter into the guarantee as security for the obligations under that subscription agreement. And Recital C explains how it's a condition precedent to the subscriber completing the transaction and therefore paying across the $500 million. The company is defined at clause 1.1 on page 38. On page 40, in the rules of interpretation, the contract provides for itself 1.4n refers to Hong Kong legal terms. Page 43, please, clause 4. Amongst Mrs. Zhang's representations and warranties were over the page on 44H that the choice of Hong Kong law will be recognised and enforced in her jurisdiction of domicile. I, that any judgment or court of or award of a tribunal obtained in Hong Kong in relation to this guarantee will be recognised and enforced in the jurisdiction of her domicile. And on page 45S, the choice of Hong Kong as the governing law of the guarantee will be recognised and enforced in the jurisdiction of her nationality or jurisdiction where her assets are situated. Page 46, clause 5.1, please. These are undertakings by Mrs. Zhang. At A, the guarantor and her spouse shall ensure their net worth shall be not less than Hong Kong $5.4 billion. And at C, the guarantor shall ensure that she, together with parties acting in concert with her, shall continue to be the single largest shareholder in the Hong Kong listed company.
The representation at 4.1a, page 43, citizen of the People's Republic of China, that was true, wasn't it?
Yes.
At the time. And domicile, I suppose, is not necessarily, well, it's not the same as residence, so it's perfectly possible that she was still domiciled in China, or not?
There it is. There hasn't been analysis of domicile, but in answer to one of the questions this morning, the judgment at paragraphs 4.2 and paragraph 10 details some of the history of Mrs. Zhang's movements, and in particular the renunciation of her Chinese citizenship only in 2019, and her move from Hong Kong, where she had formerly been resident, in 2013. So, yes, it is at least partly accurate, and there is an open question as to whether A is, in the second part, accurate or inaccurate.
So, just as at the time of the guarantee, she was a citizen of China, possibly domiciled in China, recent resident of Hong Kong, but current resident of the United Kingdom. Is that right?
Correct. Although she might say not recent because 3 years have passed.
Well, all right, within 3 years.
And I will be coming back to the substance of her residence in a moment. Just finishing on the guarantee itself, at page 47, clause 5.4, the guarantor is promptly to obtain necessary approvals from any law or regulation of the jurisdiction of her domicile and or Hong Kong to enable her to perform her obligations.
Sorry, what clause is that?
5.4.
Yep.
On that page as well is a clause to which my learned friend adverted, clause 6.2. And this is relevant because my learned friend said the first error of the judge was that focus should have been on the consumer's obligation. The default position, of course, is that the debtor, here the guarantor, would have to seek out the creditor, and that was why the assumption was Hong Kong. Here it is correct to say that it may not be Hong Kong in the event that the creditor, Eternity Sky, elects otherwise, but that would require election of a bank account in a different jurisdiction. And I'm not aware of
Are you saying the default is pay the Hong Kong? I mean, it's an on-demand guarantee.
Yes.
Yes.
And when one is asking what is the place of performance of the obligation,
Yes.
One looks to where the debtor would have to find the creditor, i.e. the creditor's place of business. Here there is a slight variation in that the creditor has the right to elect payment into a bank account in any jurisdiction.
So if there's no election, it's up to the debtor to find the creditor and the address, the relevant address provided what addresses are in Hong Kong. I take it.
Exactly so. And bear with me one moment. Still in the guarantee, page 48.
Sorry, the only place you get that Hong Kong address is in the notices provision, is it? Because it's not in the parties, that's got the incorporation address. Just trying to make sure I understand how it works.
Yes, that is right. If one was restricted to the four corners of the PG, then there is only reference to the BVI address.
Well, plus clause 12.3.
And plus clause 12.3 for notices to the subscriber. I'm grateful.
It's not quite the same thing.
Which is not the same thing. And then there is the open question under clause 6.2 as to in which jurisdiction the bank would be. But as the judge has found, Eternity Sky was a Hong Kong registered company having its principal place of business there as well. So that is, we would say, where at the time of the guarantee, rather than at the time of any subsequent demand, the most likely place of performance would be. Page 48, clause 7.1. The subscriber may convert any money received which is not in Hong Kong dollars into Hong Kong dollars being the currency in which the PG itself is denominated. And then starting on 51 and over to 52, there is the Hong Kong governing law clause and choice of HKIAC arbitration with Hong Kong seat. My learned friend talked about Mrs. Zhang taking the steps to meet the obligation in London. We don't accept that that's what would have happened, but nor do we accept that it's a legally relevant question. The legally relevant question at most is what is the place of performance of the obligation when one is looking for connecting factors for the guarantee. So we do say the Hong Kong flavour of not only the subscription agreement, but also the personal guarantee thereof is overwhelming. Mrs. Zhang's approach is to find as many ways as possible of relying on her UK residence. And we say there are three flaws with that. Firstly, it seeks to rewrite the test from connection with the contract to connection with the consumer. Secondly, Mrs. Zhang's reliance on her home in London qua asset as a connecting factor is a slender connection. There is no evidence to support the submission that her assets were UK-centric in 2016 or indeed since. And three subpoints there. A, the tribunal found that Mr. and Mrs. Zhang were some of the wealthiest people in China. That's paragraph 150. the tribunal found that the $64 million PG appeared to be for a fraction, that 64 million US dollar PG appeared to be for a fraction of their overall wealth. As at the date of the PG, those binding findings mean that Mrs. Zhang cannot argue for total wipeout. Yet she relies on a house in London worth £5 million qua asset as a UK connection. We say it's a fraction of her overall wealth and therefore insufficient. Point B, such evidence as there is shows globally diverse assets. There are some details in Mrs. Zhang's second witness statement in the arbitration. That is supplemental bundle, tab 7. It starts at page 90, but if we pick it up at page 95, there is some disclosure of other assets. It wasn't accepted in the arbitration that this was full and frank. At paragraph 20 to 21, Mrs. Zhang talks about a house in Beijing in her name. She'd never thought of it as her own, but it was. At paragraph 22, she talks about her shares in a money exchange business in Paris. But again, she never thought of it as a personal asset. And that may be why she was excusing not having referred to it previously. But it is and was an asset. Or it was an asset. I don't know the current position. And therefore detracts from this suggestion that her assets were UK-centric. We also know...
This is, as you point out, witness statement in the arbitration. Did she make a witness statement for the purpose of this application?
A very short one. For the purpose of this application...
For the application to set aside the order to enforce the award? Yes, tab 9.
Yes. I'm not sure for that application
Yes,
there was evidence, but there was a freezing order application for which there was evidence, and that, or one statement put in that respect, is also in the bundle. Tab 9, thank you. This may, given the date of 14th November, this was probably for the current application. There was then other evidence in relation to the asset position, not least because, as is mentioned by Mr. Justice Bright, there was an adjournment application before that hearing, which was heard by Mr. Justice Foxton, and questions arose at that time as well. I made the submission that the condition of any adjournment should be security, and so again, Mrs. Zhang's asset position became relevant there. And Mrs. Zhang had also been ordered to provide net asset certificates in the dispositif at the end of the arbitration award and hadn't complied with that. So we do say it doesn't lie easily in her mouth now to say that my assets are all UK-centric, and that, whether it's 2016 or now, creates the close connection. We do know that at the time of the personal guarantee, she had a shareholding in the company, Chongqing, with a market listing value of about 5 million sterling or $7 million US at the time of the PG. That's paragraph 71 of the judgment. It's in our skeleton at paragraph 55.3. In summary, there is no good evidential basis for Mrs. Zhang to say there is a separate ground of connection with the UK based on her assets being predominantly here, as well as her residence here. The third flaw in the over-reliance on her residence is that it was also a limited residence, in that not only had she only arrived in 2013, but she spent substantial periods of the year overseas. For that, please, it's supplemental bundle, tab 5, page 67. Here there is a schedule of Mrs. Zhang's absences from the UK after she became resident here in 2013. So in 2014, 107 days were spent absent from the UK, predominantly in China. 2015, there were 86 days away, again, mainly in China. 2016, which covers the time of execution of the guarantee, there were 78 days away. And if one looks in the middle of that third group of rows, one sees the trip to Spain. And that was when we know now the PG was signed. So to the extent Mrs. Zhang was still a global citizen, albeit now having anchored herself in the UK, that lessens any weight to be given to her UK residence when considering whether the PG had a close connection with the UK.
Was this schedule of absences agreed?
I don't recall its derivation and therefore which set of lawyers drew it up, but I don't understand it to have been.
And how do you have absence from the 3rd to the 4th of July with 0 as days absent?
That is a curiosity.
They're presumably counted complete days.
Yes, an overnight trip of fewer than 24 hours? I don't know.
They may have counted complete days rather than days of travel.
Yes. There. The point is not as such a granular one, but one of impression as to Mrs. Zhang being, consistent with a number of very wealthy people, relatively international in her movements, and therefore the UK residence not being comparable to that of someone who never leaves the UK.
This is according to the index. This is dated the 17th of December 2018, which seems quite an early date to be compiling such a document. Can you tell us at any rate what this document is and what it's compiled from and what status it has in our bundles?
I will get back to you on all of those questions. It may interrelate with the point we saw in the award this morning, where during the build-up to the arbitration hearing, Mrs. Zhang had originally said, I signed the PG in London, and then on analysis, her lawyers had said, that doesn't seem possible because you were in Spain, and that correction was made. And so it may be that, for reasons related to the arbitration,
It was her lawyers, was it, who pointed that out rather than your side saying gotcha?
I will come back on that as well.
If I can assist, I think it did come from Eternity Sky's lawyers. I think I haven't been through the dates with her.
So she must have given some document, whether her passport or something like that,
It must have
which
been
would
some kind of
indicate her movements.
Yes,
Yeah.
we'll find out precisely what the position was.
I mean, is this either completely or broadly agreed as an
I don't think I can go that far. The point we made in the talk below was that it broadly reflected the school holidays, and Mrs. Zhang had a daughter in the UK and family in China, and that was our submission. But I don't recall quite what the judge said about it. But I don't think it was a significant feature in his decision.
Yes. Thank you.
The final issue on close connection is as to the alleged relevance of post-contractual events. Our submissions on that are paragraphs 23 to 28 of our skeleton. We say the judge was right to be sceptical at judgment paragraphs 103 to 104. There are three reasons why, if this point is necessary to decide, we say connection should be tested as at the date of the contract, rather than, as Mrs. Zhang effectively says, at the date of the hearing. First, as per paragraph 24.1 in the skeleton, that fits best with the purpose of section 74.1 and with the CRA more generally. Section 74.1 has a test to decide whether to bolt on the Consumer Rights Act to the chosen law, the law that is chosen at the time of the contract in the contract. Also, in terms of the purpose and wording of section 74.1, testing it at the date of the contract fits best with the use twice of the present tense, as identified this morning. More generally, the directive, as we saw when looking at Commission in Spain, identifies the mischief against which we're guarding as the loss or deprivation of protection at the time of the contract. That is most consistent with a test that queries the close connection at the time of the contract. As to the CRA more generally, it regulates the entry into contracts and places an onus on the trader prior to and at the time of conclusion of the contract. Substantive unfairness is explicitly tested at the time of conclusion of the contract. That is section 62, 5b of the Act. It's also confirmed by the CJEU in the case of Andriy Chuch and Banca Romanesta, which is in the authorities bundle at tab 45. But I won't go there in the interest of time, unless your lordships wish me to. The key paragraphs are paragraphs 53 to 54. And one of the reasons the court gives as to why one tests substantive unfairness at the time of the contract is because one is looking at whether there was a significant imbalance at the time of the contract. And that includes, of course, whether the trader could reasonably have expected the consumer to agree to the term in question in individual negotiations. Strictly speaking, before the time of the contract. We say it will be inconsistent with the application of the unfairness test at the date of the contract to address the logically prior question of whether that test is engaged at all, close connection, for a foreign governed contract by reference to a later date. Effectively, they say, the hearing date. For completeness, though, we do acknowledge how a similar dilemma has been resolved before the English courts in relation to the Rome I regulation. Civil lawyers don't take the same approach to post-contractual events as we do in this jurisdiction on a number of issues. And the way that this has been reconciled in the authorities is that post-contractual events can be relied upon to shed light on the position at the time of the contract. And that is, we say, as far as the matter should ever go. And that proposition is set out again in Dicey, which is tab 60. Hard copy 1907, so it will be E version 1884. Paragraph 32060 addresses the question of the relevance of post-contractual events for the purposes of Article 4, and it explains how the English view that subsequent conduct cannot be taken into account in construing a contract is not shared in other countries. And then in the penultimate line, accordingly, the English court should be entitled to take subsequent conduct into account at least to the extent that it sheds light on the intention of the parties or on the country with which the contract is most closely connected at the time the contract was concluded. So it's not about taking into account any changes post-contractually. It's just about allowing post-contractual evidence to shed light, to inform the position as at the date of the contract, which remains the touchstone.
When assessing closest connection, it seems from 3258 that you don't take into account post-contractual matters. Do we get any help from that?
I wouldn't put it that highly, because 3258 is probably recounting the common law position which preceded Rome I, based on the Amin Rashid 1984 decision. And that, of course, as a matter of English common law, was consistent with quite a bright line that one never looks beyond the date of a contract. The second reason why unlimited consideration of post-contractual events is the wrong approach is uncertainty. That's paragraph 26 of our skeleton. No elaboration required. The third reason is that unless the law was clearly to stipulate otherwise, this would have to be a two-way street. Supervening events could lessen the connection of the contract with the UK, and so by the time of the hearing, deprive the consumer of protection that had existed at the time of the contract. And that could be exemplified by my learned friend's example of a consumer emigrating. And we don't rely upon that. We say you test at the time of the contract. Finally, we say this doesn't arise on the facts, as the judge correctly held. There was no evidence before the judge, and is none before this court, that there was a relevant increase in the UK centricity of Mrs. Zhang's assets since the PG concluded. I've already shown details of assets in other jurisdictions. As to the 4 other points made this morning, number 1, Mrs. Zhang remaining in the UK does not increase the connection, so it doesn't engage this question of post-contractual events. Number 2, enforcement proceedings here are irrelevant, we say, but there was also enforcement in a practical sense in Hong Kong, where the arbitration took place and where one might have assumed Mrs. Zhang would meet the award. There are also enforcement proceedings ongoing in the BVI based upon the Hong Kong award.
Do we have evidence of that?
No, that is not on the record. It is in a similar category to Malone Friends' insolvency proceedings, which is his 3rd point. And on that, we accept there are those proceedings here in relation to Mr. Zhang's estate. And we say they are irrelevant. They are remote from Mrs. Zhang's personal guarantees. The 4th point is...
if it assists Malone Friend, we accept there are proceedings in the BVI.
That Mrs. Zhang's 2019 acquisition of UK citizenship is irrelevant. We confirm, or we say the judge was correct to find that there should not be discrimination for these purposes as between citizens and non-citizens, and that works both ways. But if that's a legitimate point to make by Mrs. Zhang today, it bites back in the sense that she was not a UK citizen in 2016, which is the time when we say matters should be tested.
If you're looking at the quality and strength of connection of somebody with the UK, I would have thought it's not discriminatory to think that somebody who is a citizen here has demonstrated a commitment to and permanence in this jurisdiction, as compared with somebody who is a visitor, somebody who has, as my lord floated this morning, indefinite leave to remain, maybe for a limited period, or those are all factors which might bear on strength of connection, I would have thought.
I accept that, and we say, therefore, in 2016 there wasn't that strength of connection. But we also emphasise that one is now getting many shades removed from the question, does the contract have a close connection with the UK? So unless there are any questions, that's ground 1 on close connection. And I can take ground 2, transparency, more quickly. The ground is in Malone & Friends skeleton on page 32 of the core bundle. The court erred in concluding that clause 2 was transparent and prominent within the meaning of section 64 CRA. This is the threshold requirement if Mrs. Zhang is to avoid the core exemption in 64.2. While the grounds mentioned prominence, the focus has been on transparency. We say the judge was right for the reasons he gave at judgment 137 to 164. The starting point is, as the judge identified at 140, the relevant average consumer. Unpacking the identity of the relevant average consumer, we make the points at paragraphs 32 to 34 of our skeleton. First, reasonably well-informed, observant and circumspect by statute, section 64.5. A reasonably observant and circumspect consumer can be expected to read the relevant documents and seek to understand them, at least in any substantial transaction. And on this, we say the court should endorse the dictum of Mr. Justice Kitchen, as he then was in the OFT and Ashburn case, my learned friend mentioned. That is Authorities Volume 1, tab 26, please. The OFT sought declaratory relief in relation to alleged unfair practices by a low-end gym group in its recruitment and retention of new members, and the OFT contended certain terms were unfair, contrary to the 1999 regulations. The key paragraph is hard copy page 630, which will be e-bundle 607, please. Paragraph 128. Starting a few lines down, the concept of a typical or average consumer is a familiar one. Such a person is generally assumed to be reasonably well informed and reasonably observant and circumspect, and to read the relevant documents and to seek to understand what is being read. So that's my first point. And now we move on to my second point. The standard is a variable one and must, I believe, take colour from the context. For example, consumers who are financially sophisticated may be expected to bring to bear a greater understanding of the meaning and implications of the terms of a contract than consumers who are vulnerable as a result of their naivety or credulity.
Can we just pause on that, because that suggests there isn't a notional average consumer, even for a gym membership. You might be looking at individual characteristics, just looking at what those words say.
I agree that's one interpretation. In context, we say that Mr. Justice Kitchen is not departing from the objective nature of the test, which will be my third point, but is instead saying that one is looking at a class of persons who are financially sophisticated. So if one looks at the type of transaction, one may be able to say that that type of transaction is generally entered into by a person who can be expected to bring to bear a greater understanding of the meaning and implication of the terms of the contract.
So we should expand, should we, what Mr. Justice Kitchen says, so that it's not consumers who are financially sophisticated, but consumers who typically enter into this kind of financially sophisticated contract. Is that a sense of what you're saying or not?
We do say that that's what it means in context, yes, because if one is to keep it objective and to look at the type of contract in question, then one is, as the judge identified, looking at a class of persons who enter into that type of contract to identify the relevant average person who enters into that type of contract.
It is possible to apply an objective test by reference to the characteristics of individual people, but I don't think you're saying that. In other words, you could distinguish between different types of gym customers, either those who are naive and can't read properly, but I don't think you're saying that. You're saying the variability is only as between the type of contract, and you adjust your concept of average consumer accordingly.
I agree that's possible, but I'm not going that far because I may then butt up against the CJEU authorities that say, for example, lawyers are consumers nonetheless, and the fact their lawyers may actually be irrelevant on the facts. And if we were to start to look too narrowly at the characteristics of the individual as opposed to the nature of the contract, then we might end up slicing the salami too many times.
Well, if you look at paragraph 155 of this judgment, which is another of the sideline passages, Mr. Justice Kitchen seems to distinguish between the relevant average consumer interested in a low-end gym club and a high-end gym club, which suggests quite thin salami slicing.
It does, but as a function of the contract with a low-end gym, as opposed to the contracts with a high-end gym, rather than as a function of the.
So how do you define the relevant average consumer in this case? Mr. Kirk defines it as a reasonably well-informed family member who is asked to sign a personal guarantee for the benefit of another family member's business.
We say that the extreme facts of this case lead to an oxymoron. It is the average consumer entering into a personal guarantee of a Hong Kong $500 million convertible bond issue by a Hong Kong listed company. As the judge identified at 145 and 146, that is an unusual and narrow class of persons. There will very often be a correlation between the two different categories we've just been discussing. But the definition of the relevant average consumer should flow, at least predominantly, we say, from the nature of the transaction. My lady friend is wrong to say that there's a one-size-fits-all family member guaranteeing another family member's business. Whichever of those two approaches one takes, one cannot sensibly apply a variable parameter as to relevant average consumer in the same way to the personal guarantee of a loan to a sole trader with a small holding and a very low turnover as to a substantial, or the guarantor of the obligations of a substantial company listed on a stock exchange. They are, just as the high end and low end gym customers are different, so those guarantors are different, relevant average consumers. And so the question is, how would that average consumer behave and understand clause 2? The third point is that the test is objective. That's paragraph 34. Now, my learned friend took, we say, the duty of transparency too far, even with his elderly couple example. His case would impose additional due diligence on lenders as to not only the extent of risk being taken, for example, one is guaranteeing £50,000 as a loan plus 5% interest, but also as to the probability that the risk will materialise, i.e. as to the risk of default by the company being guaranteed. The trader may not know fully the exposure in the sense of that probability. The trader will not usually know the specific implications of the guarantee on the guarantor if the guarantor is called upon. That depends upon the guarantor's private position. So we don't accept that there's any duty to warn of the probability that a guarantee will be called upon. And on that, before I turn to the application of the relevant average consumer transparency test to the facts, I want to distinguish the authorities cited by Mrs. Zhang and the CMA on transparency. They are fourfold, but I will only address the one that my learned friend referred to this morning. So the four authorities are the Van Hove and CNP and BNP Paribas and VE cases relied upon by Mrs. Zhang at paragraphs 34 to 35 of her skeleton, and then the Kasler and OTP and Mate and Volksbank cases relied upon by the CMA at paragraph 36 of their submission. I have 3 points which apply to all 4 of those authorities. The first is that each of the dicta relied upon is specific to the type of transaction and must be read in context. Secondly, each of those transactions is, on analysis, more complex than a personal guarantee. A personal guarantee of a loan or a bond is a straightforward concept. The economic consequences are plain. If the guaranteed party fails to pay, to repay the principal sum, then the guarantor can be called upon to pay. The extent of risk is a function of the sum guaranteed as to principal and interest. But a large sum does not in itself denote any complexity in the transaction of guarantee. The third point on all 4 of those cases is that each of the average consumers in those cases could not be expected to bring to bear an understanding comparable to that of the relevant average consumer guaranteeing a listed company's $64 million convertible bond issue. That's the OFT point.
Sorry to interrupt. How does your third proposition fit with your average consumer who we test by reference to these transactions that you've just told us were more complicated than personal guarantees?
So we identify the characteristics of the relevant average consumer by reference to the nature of the transaction, not its complexity. Its complexity will determine the extent of the duty when one is looking at transparency. But when we are identifying the relevant average consumer, we say, is it someone who enters into low-end gym membership contracts and we give them characteristics accordingly? Or is it someone who enters into personal guarantees of enormous corporate bond issues and we give them characteristics accordingly? Then at the next stage, when we are assessing whether the relevant terms are sufficiently transparent, we will need to identify the complexity of the transaction. And there will then be a commensurate impact upon transparency. And when one looks at those 4 cases, I'll only go to the Van Herve one sees that there is that correlation between complexity and the onus in relation to transparency. And so that's why I draw this distinction that the personal guarantee, notwithstanding its high stakes or high value, is relatively straightforward. So the Van Herve case you were shown this morning is at Authorities Bundle 1, tab 36. And if one starts at page 926 of the hard copy bundle, which will be page 903 e-bundle, the relevant consumer here was the borrower of an aggregate of about 65,000 euros, who then entered into ancillary credit insurance. And the insurance contained the ambiguity, which is over the page at paragraph 12, under the second clause of the contract, an ambiguity as to when the insurance would kick in, which related to total incapacity for work. And Mrs. Zhang relies on paragraph 41, which is on page 931. And the key to identify here, as with all the other paragraphs on transparency relied upon by both my learned friends, is that the information is to concern the specific features of the arrangements for covering the loan repayments. So each time the CJEU looks at one of these transparency questions, it focuses upon the specifics. The point that transcends is that the consumer must be able to evaluate the economic consequences. And here that's not clear because of the ambiguity in the insurance contract. In relation to the other cases, it's not clear because there's an uncapped foreign exchange risk. That's the BNP Paribas and VE case, and the Kasler and OTP case. And in Mate and Volksbank, the problem was that the lender had a right to vary the interest rate and to levy a risk charge. But in terms of evaluating the economic consequences of a guarantee of a loan for a fixed sum, the evaluation is straightforward. The economic consequence is that if Chongqing defaults, then the guarantor can be called upon to pay the $500 million plus interest on the face of the guarantee, the default interest, although in the event that hasn't happened. So we do say
it's on the face of the subscription agreement, isn't it? Not the guarantee, the default interest.
Yes, that's right.
So, and I think Mr. Kirk's point is that in order to find out what the liability is, you've got to know what the transaction documents are, because they're not identified in the personal guarantee. So you've got to find the definition in the subscription agreement. You've then got to get all the documents and look at them. And when you do look at them, you'll see that the liability is 500,000, but you'll also see there's a penal provision for interest which might or might not be enforced. So how do you know what your economic consequences are without going through all that exercise?
It is necessary to have the guarantee and the subscription agreement. I accept that, because the interest rate is only specified in the subscription agreement. And that's where the relevant average consumer comes in. And we pick this up at paragraphs 36 to 40 of our skeleton. And we emphasise three apparently unchallenged findings. First, that the relevant average consumer would have had a good understanding of PGs and bonds. And we say the reasonably well-informed, observant and circumspect person executing a PG for a 500 million Hong Kong dollar convertible bond issue would be expected to understand well both those issues. Secondly, there's no challenge to the finding that the relevant average consumer would have read the PG, and that's obviously correct given the context. The reasonably circumspect person would not enter into such a commitment without doing so. They would not negligently refrain, as Mrs. Zhang did. And we do say that that relevant average consumer, and this is the answer to the question, would have read not only the PG, but also the subscription agreement. Before signing the PG, one wanted to look at the underlying contract, which was being, the performance of which was being guaranteed. Thirdly, there's no challenge to the finding that the average consumer would have taken legal advice consistent with their reasonable circumspection. And we say that those three findings are, which we've set out at paragraphs 36 to 40, are the background which make the judge's finding of transparency correct. When one has posited the right type of relevant average consumer, then that objective consumer could readily evaluate the economic consequences of the PG, namely by reading the PG and the subscription agreement. Yes, the interest rate is only in the subscription agreement. Yes, the definition of transaction documents is only in the subscription agreement. But that hypothetical person would have studied both. That takes us to the three responsive arguments at paragraph 42 and following of our skeleton. We say that Mrs. Zhang overinterprets the reference to the details guaranteed being obscured, and we do say that they could have been evaluated with or without legal advice based upon the relevant average consumer. On this, there is a paradox in Mrs. Zhang's case. She's arguing that a reasonably circumspect average consumer reading the contractual documents would not have understood the economic consequences, whereas she, as the negligent guarantor who wasn't bothered to read them, did, in broad terms, understand the economic consequences, the responsibilities that were being undertaken. And for that, we rely upon the references to the award that we have given in our skeleton, and in particular paragraph 44 of our skeleton, referring to the award at paragraph 101. So that's our first responsive point. The second over the page is that the judge was correct that a personal guarantee will likely incorporate by reference. This reinforces why we say the relevant average consumer would read both contracts. On that, there are 2 points in the award to mention again. First, while it was a hypothetical, Mrs. Zhang accepted that she would probably have been provided with a copy of the personal guarantee if requested. That was paragraph 175. And we say the same would follow for the subscription agreement. Secondly, the tribunal...
Well, I suppose you would say that the reasonable average consumer who makes a request for a document but is not given it will not sign.
Yes. Exactly so, and in this case, I think, as my learned friend said, if they asked for the subscription agreement and weren't given that, but were only given the personal guarantee in full, would not sign. And then the second point from the award is that the tribunal found that Miss Liu, Mr. Zhang's PA, and Chong Sing acted as her agents for the purposes of procuring and attaching her signature to the personal guarantee. We say, self-evidently, they had access to the full documents and could have passed them to their principal, Mrs. Zhang, if she requested them. Thirdly, contrary to Mrs. Zhang's appeal, the judge's findings do not depend upon the average consumer having taken legal advice. The judge made that clear at paragraph 1623. We do say that Mr. Justice Hitchin's relevant average financially sophisticated consumer who can bring to bear a greater understanding would have understood the economic consequences without a lawyer. My learned friend relied upon various matters from paragraph 60 of his High Court skeleton. We don't accept that when Eternity Sky lent 500 million Hong Kong dollars to Chong Sing for 3 years, it knew there was a high risk of default and insolvency. And we say those matters should be disregarded. There is no evidence upon them. So we say the judge was obviously correct in his finding that the relevant average consumer would take legal advice before concluding a contract of this sort, even though that is not a necessary part of our case. We say that in all the circumstances, taking legal advice would be a natural consequence of reasonable circumspection. There is no bright line rule that in every case it must be assumed the consumer will act without legal advice. The likelihood of legal advice is relevant to what is required in terms of setting out the mechanics of the economic consequences. So unless there are any questions, those are my submissions on transparency. I move on to my third reason why the appeal should be dismissed, namely that it is demurrable because ground 2 goes only to transparency under section 64 and not unfairness under section 62. 3 short points. First, the judge made distinct findings. At judgment 143, he trailered the different points where he said, before referring to Director General of Fair Trading and First National Bank, that significant imbalance and requirement of good faith were of more direct relevance to the assessment of substantive fairness rather than the threshold question of transparency under 64.2. And then in paragraph 164, he made the 2 separate findings, the second of which is not the subject of any ground of appeal or permission to appeal. The second short point, substantive unfairness was not overlooked in the formulation of Mrs. Zhang's grounds of appeal. It was simply not the subject of the grounds on which permission was granted. We see that from the order in Core Bundle tab 4 at page 72. Mrs. Zhang had 3 grounds upon which permission to appeal was sought. Grounds 1 and 2 familiar. Ground 3, the court wrongly refused to grant further time for the applicant to complete her investigations regarding substantive unfairness. So ground 3 sought to put substantive unfairness, the section 62 question, into a holding pattern. The background to that is in the judgment at paragraphs 207 to 208, and a tension between the positions taken by Mrs. Zhang's 2 different leading counsel below. If one then turns over to page 73 of the order, paragraph 8, Mrs. Zhang was refused permission to appeal on ground 3, so refused on the only ground that covered substantive unfairness. Third and final point, the tests for transparency and substantive unfairness are distinct. Even if transparency is one aspect of substantive unfairness. Substantive unfairness is the full test, as Malone and Friend put it. We don't accept that the appellate courts have a duty under section 71 to consider substantive unfairness anyway, where it has already been considered by the first instance court and is not the subject of any permission to appeal. The difference between the tests is
But
patent.
that would, I suppose, override the requirement for permission to appeal. You could ask for permission to appeal and not get it, and then turn up in the Court of Appeal and say, you've got to do it.
Yes, and the jurisprudence doesn't go that far. And we say the difference of the tests is patent from the CRA itself. The core exemption applies only if there is transparency, section 64.2, and the substantive unfairness test is then separately in section 62, to which ground of appeal 2 makes no reference. One authority to show on this, before I conclude, the CMA guidance, that is in Authorities Bundle 2, tab 56, and in the hard copy it is 1659. So it will be 1637 E bundle. It is paragraph 2.6 of the CMA guidance. The first sentence says this: failing this specific transparency test alone, independently of the fairness test, does not make a term unenforceable against an individual consumer in the same way as a finding of unfairness. And then over the page, turning on to page 32 of the document, maybe easiest, 2.49, a term that fails to meet the transparency test alone is not, like a term that creates an unfair imbalance, unenforceable against the consumer. There's a separate consequence that's set out in relation to ambiguity, which is rather like contra proferentum. So the separate inquiries as between transparency on the one hand and substantive unfairness on the other can also be seen from the authorities in relation to substantive unfairness, and unless your lordships wish me to do otherwise, then I would continue to address them tomorrow morning in relation to our fourth reason why the appeal should be dismissed.
Yes, very well. All right, we'll adjourn now until 10:30 tomorrow. Thank you very much.
She went last. That's what they'll say to her.